So very good afternoon. Let me take attendance. Ankit, Ayush, Meghna Dhuria, Navya Singh, Sambhav Garg, Samriddhi Tripathi, Sanya, Sarvan Sinha, Saurav Yadav, Shara, Shreya, Tushar, Vanshika, Vatsan, and Yashwardhan. So I will take attendance again at the end. Okay, so very good afternoon to all of you. So let us start from where we have left yesterday. Fine. So where we have left yesterday, we will start from there itself. Okay, so here we go. Yes. So yesterday we studied about the debentures, and we also studied about the distinction between debenture stocks, and there are various types of debentures, kinds of debentures on the basis of convertibility, security, redemption, registration of the instrument, and we studied these in detail also. Finally, we just studied about the debenture stock, and we have also studied the difference between the debentures and shares. Okay, so today we are going to see the provisions of Companies Act 2013 regarding the issue of debentures. So that we will be doing today. Fine. So if you have any question, any confusions till yesterday, so you may please ask anything if you want to, or if you want me to start, go ahead further. Please tell me so that I can do it. Shara, I think you are able to understand all the things which I have taught till date.
Yes, sir.
Very good. Navya, Vatsal Rastogi.
Yes, sir.
Good. So where is Navya Singh? Navya Singh, she has not replied me back. Sanya, you there?
Yes, sir.
Okay. Yashwardhan?
Yes, sir.
Okay, fine. So should I proceed further? Okay.
Yes, sir.
Okay. So let us just see the issue of debentures and issue of debentures to be approved by a special resolution, because the first most thing which we have studied about the debenture is that you cannot issue a debenture, you cannot take a loan until unless it has been approved via special resolution. So section 71(1) states that a company may issue debenture with an option to convert such debentures into share, either wholly or partly, at the time of its redemption. So issue of debentures with an option to convert such debentures into shares wholly or partly shall be approved by a special resolution passed in a general meeting. So you have to go for a special resolution in the general meeting, and general meeting actually happens from the it is a general meeting of the shareholders. Okay, so there are various types of meetings also. We will be studying in detail about the meetings where the decisions are taken, where the resolutions are passed, and the companies work accordingly. Okay, so the meetings over here, in this case, because yes, you are taking a loan and you are making it convertible into shares. Okay, because why it is passed over here in the general meeting? Because when the debentures are converted into shares at the time of redemption, the supply of shares in the market will increase and it will adversely affect the price of the existing shareholders. So these existing shareholders are Now also the shareholders whose price will be getting affected. So there has to be one approval from these people in the general meeting, and that too by a special resolution. Then only you are allowed to issue such shares which are either wholly or partly convertible into equity shares at the time of redemption. Okay, now further no debenture shall carry the voting rights. So section 71(2) states that no company shall issue any debentures carrying any voting rights, because voting rights are with the shareholders and you cannot take away their rights. So secure debentures to comply with the terms and conditions prescribed. Okay, so secure debentures, sometimes secure debenture people also try to interfere in the affairs of the business. So there are certain terms and conditions specially designed for these secure debentures, to what extent they can exercise their powers or their veto in the companies itself. Otherwise, normally the debenture should not comprise of any voting rights, and even the secure debentures also cannot just have the voting rights as such. Okay, but there are certain conditions subject to which they are issued, and then these conditions are also prescribed, and these conditions are given under the company's shares and capital rules 2014, and following are the conditions. Number one, the company shall not issue secured debentures unless it complies with the following conditions, which are: a issue of secured debentures may be made provided the date of its redemption shall not exceed 10 years from the date of issue. So what rule says? At present, the redemption must be within 10 years. So any secured debentures which are issued by the company must be redeemable within a period of 10 years at present. Okay, the company engaged in setting up of infrastructure projects may issue the secured debentures for a period of exceeding 10 years, but not exceeding 30 years. Now, why this privilege has been given to the infrastructure projects company? Because the infrastructure projects themselves will start generating the funds after a certain period of time. And when we talk of infrastructure, it takes time to build the infrastructure. And if the company will issue a share, will issue a debenture which is payable within 10 years, the company may not be able to fulfill its objectives for which it has taken, or which it has raised the debenture or has taken the loan. Okay, and because the construction of infrastructure takes a lot of time, so that's why the time has to be allowed, and accordingly the decision has to be taken. Okay, so next is such an issue of debenture shall be secured by creation of charge. Which debenture? Secured debenture. So such issue has to be secured by creation of charge on the properties of the assets of the company having a value which is sufficient for the due repayment of the amount of debentures and interest thereon. So the you can say the assets of the company which are to be attached, on which the charges are to be created, or which are to be secured, or which are to be mortgaged through the charges, must be more than the value of the debentures and interest payable thereupon. Okay, next is section 71(4) states that when debentures are issued by a company under this section, the company shall create a debenture redemption reserve. So this section is regarding creation of debenture redemption reserve account out of the profits of the company available for payment of dividend, and the amount created to such account shall not be utilized by the company except for the redemption of debentures. Now, what the thing is, the law also is facilitating. The law is also facilitating the company by compelling it to create a debenture redemption reserve account, so that at the time when the time of redemption comes, the company may not go into liquidation, or the company must have sufficient funds to redeem its debenture which it has issued. Though the company has actually created a charge on the assets, but the assets of the company are not supposed to be sold off for repayment of the debentures. For that purpose, a separate fund which is called debenture redemption reserve account is to be created in which the company will put the money as per as per prescribed by the law, and it will create a reserve, and this amount will be used only and only for the redemption of debentures and nothing else. Rule 18.7 of the company's shares capital and debenture rules 2014 prescribe the following condition: that a company shall create a DRR for the purpose of redemption of debentures in accordance with the following condition. Number one, DRR shall be created out of the profits of the company, means out of the profits which are available for the dividend, means normal profit. You can say the revenue profits of the company, which the company may be earning revenue out of it. A company shall create DRR equivalent to less than 50% of the amount raised, okay, through the debenture issued before debenture redemption commences. So what the thing is, so here, because why it is saying 50%, because this amount will be invested somewhere else also. It will also generate some more interest. So that will be, so at least 50% of the amount which has been raised should be, the fund should be created with that particular amount. Okay, the company shall appoint the debenture trustee. Now, who will manage this fund? The company shall appoint a debenture. We will study about it, the appointment of debenture trustee also. So the company shall appoint a debenture trustee before the issue of the prospectus or the letter of offer for subscription of its debentures, and not later than 60 days after the allotment of debentures. So debenture trustee has to be appointed who will take care of this particular fund. Okay, and this appointment must happen within 60 days after the allotment of debentures. So not later than 60 days. So within 60 days, the company has to appoint the debenture trustee to take care of the fund which has been created for this purpose. Okay, and what I will do, execute the debenture trust deed to protect the interest of the shareholders. So what will happen? Not only the trustee will be appointed, but at the same time, debenture trust deed will be created to protect the interest of the debenture holders. And then the security of the debentures by way of charge or mortgage shall be treated in the favor of debenture trustee. So debenture trustee is the whole soul, you can say, the person who will be having the charge of the debentures issued by the company and the money which has been transferred to the debenture redemption reserve. So he will be actually the guard of the money which is to be saved. Okay, so he will act as a guard of the this particular fund which has been created, and he is actually the guard of the debentures which has been created. Okay, so so what he will do, sir? So there will be a trust deed which will be created in the favor of debenture trustee. So any specific movable property of the company not being in the nature of pledge, these all will be under the charge. So who will create the charge? The company will create the charge, or mortgage has to be created on the assets of the company, and it can be on any specific movable property of the company. Okay, and any specific immovable property, whatever whatever situate or any interest therein. So this has to be created. So every company is required to create a debenture redemption reserve, shall on or before the 30th April in each year invest or deposit. I told you it will be invested because the funds once created by the company has to be invested somewhere else in order to generate some return out of it. Okay, so the amount which has been credited every year in the debenture redemption reserve shall be invested before 30th day of the April in each year. So it will be invested or deposited as the case may be, a sum which shall not be less than 15% of the amount of its debentures maturing during the year ending on 31st day of the March of the next year. So for example, if the debenture, suppose the debenture of rupees 1 lakh is outstanding. Also, it is outstanding outstanding by the upcoming March 31st, 2021. So the company has to transfer 15,000, that is 15% in the debenture redemption reserve, and such amount should be invested, not only transfer. Such amount should be invested before 30th of April in the year, so that the entire year is there in order to earn the interest, and it should earn the interest or the return on that particular amount which is invested by the debenture redemption reserve. So there has to be debenture redemption reserve. Investment account is also to be created. I hope you have understood this, and you might be doing the accounting portion while you are studying the corporate accounting in your regular class, I suppose. So please ask for the entries from your teacher who is teaching you the corporate accounting regarding the creation of the debenture redemption reserve and how it is treated in the books of accounts. Okay, will you ask? Come on.
Yes, sir.
Yes, sir.
Fine. So, and then why I'm telling you to ask? Because in that way you will be able to link both the subjects. And if you study one, the other you will also be able to understand instantly. Is that okay with you? Shreya?
Yes, sir.
Yeah. So it should not be less than 15% of the amounts of its debenture maturing during the year ending on 31st day of the March of the next year in any one or the following methods. So these are the methods which are given. Okay. So where it can be invested, either it can be in the deposits with any scheduled bank that is free from any charge. There should not be any charge or lien on it. Otherwise, the very purpose of creating this fund will be defeated. Okay. So these funds should be freely available at the time of redemption, and so that when the redemption happens, then you receive the fund. So at that time, I can also tell you the entry at the time when you will be selling these debentures, you will pass entry bank account debit to debenture redemption reserve investment account. So that investment account will be closed, and this amount will again be transferred to the debenture redemption reserve, and you will pay off the debentures, and you will pass the entry debentures account debit to debenture redemption reserve account, and it will be closed. Okay, so please ask these entries also, because I have already done all these things because I am a company secretary, so I have already done it. But you must also understand how it is to be done. Okay, but I can't go beyond my subject. But though I have told you some entries also, you can please ask the teacher who is teaching you this corporate accounting. Okay, so let us just proceed further. So such investment can be in deposits with either in scheduled commercial bank, free from any charge or lien. Secondly, it in encumbered securities of central government or any state government. Okay, encumbered securities mentioned in sub clauses A to D and EE of section 20 of the Indian Trust Act. So there are certain securities, and that also includes the post office securities too, where investment can be done. So why this is being declared as such? Why? Because these all are the secured resources of the central government, or you can say this or the government related to that particular area. So why you are giving it? So that at the time of redemption of shares, or sorry, at the time of redemption of debentures, you can actually take the money from the bank and redeem your debentures, or you can say the bonds issued by the any other company which is notified under clause F of section 20. Okay, or the amount invested or deposited as above shall not be used. This is very important. The above amount shall not be used for any purpose other than for redemption of debentures maturing during the year referred above. Okay, provided that the amount remaining invested or deposited as the case may be shall not at any time fall before 15% of the amount of the debentures maturing during the year end on 31st day of the that year which is coming up. So it should not fall below 15%. Okay, now here again the important thing is that why it is to be maintained. Just remember one thing, because the payment is to be made to the debenture holders and it should not be bounced. Okay, so that's why this is the purpose for why this account has been created. Next is, in case of a partly convertible debentures, debenture redemption reserve shall be created in respect of non-convertible portion only. Because for convertible portion we have to create the full amount. full, and then non-convertible, because in conversion what will happen, we will not be requiring any money, because at the time of redemption all will be paid in the form of shares. So debentures will be converted into shares at that time. But if it is a partially convertible, in that case part is to be paid in cash, or you can say part is to be paid to the shareholders, and the remaining can be paid in the form of shares, because it has an impact that the company will be issuing shares to that particular company. Okay. Next is the amount credited to the DRR shall not be utilized by the company except for the purpose of redemption. This is coming again and again. This is a very important point. Okay. So this is all about the creation and the management of your debenture redemption reserve. So any question till now? Anything you would like to ask? यार आप पूछते ही नहीं हो कुछ. श्रेया.
Yes, sir.
क्लास बड़ी डल क्लास है, कुछ पार्टिसिपेट ही नहीं करते हो यार. चलो आ रहा है ना समझ में, मेरा वो कंसर्न रहता है.
Yes, sir.
Fine. चलो. Let us now just talk about debenture trustee. चलो मैं पूछता हूँ. Who will tell me who is debenture trustee? Or I will ask you. Who is debenture trustee? Anyone? Raise your hand. Okay, मैं पूछता हूँ यहाँ से. मेघना धुरिया. Are you there? Meghna.
Yes, sir.
Meghna, what do you mean by debenture trustee? Can you please switch on your video?
Sir, I am out.
Okay, Meghna, please tell what do you mean by this debenture trustee? Who is debenture trustee? Yes, Meghna. नहीं मालूम? नव्या सिंह.
Sir, those who are the holders of the debentures in a company.
Debenture trustees are the holders of the debentures.
Yes, sir, in a company.
Of course, in a company, debentures happens in a company only.
Yes, sir.
What is the function of debenture trustee?
Sir, debenture trustee is the holder of debenture stock for the benefit of another party.
What else?
Else I don't know, sir.
I've told you
So
he is a
holds
debenture redemption reserve and debentures funds. Navya Singh. Navya Singh, what is debenture trust deed? Navya, not there.
Yes, sir. Yes, sir.
Where
Sir,
are
actually,
you?
I'm driving.
Driving?
Yes, sir. Hello.
Yeah, Sanya. Yes, Sanya, can you tell what mean by debenture trustee and what is debenture trust deed?
Sir, a debenture trustee is someone who acts as an intermediary between the debenture issuer and the debenture holder. And the debenture trust deed is basically a document that secures your debentures so that the trustee can help the investors, and that's just that.
That's it.
Yes, sir.
What are the functions of debenture trustee? Okay, Sanya, very good. Shara,
The debenture trustee holds secure the property on behalf of issuer company,
excellent. Vanchika, will
like
you tell the remaining things?
mortgage in favor.
Good, good, good. Vanchika, where is Vanchika?
Yes, sir. Sorry, sir. I'm having some issues with my internet right now. Can you repeat it again?
What are the remaining functions of debenture trustee? What he does?
Sir, debenture trustee actually safeguards the interest of the debenture holders.
Okay, by doing what?
Uh, by doing, I don't know.
By executing the deed, because debenture trustee deed is executed in favor of debenture trustee, who is the whole sole guard of the debentures funds, and he is on the only person who actually manages the debentures fund. Without his permission, nothing can be done. Okay,
Okay, sir.
fine. So let us now proceed further. I can see a good participation from your class also. So next is a debenture trustee, means a trustee of a trust deed for securing the issue of debentures of a body corporate. So how they are appointed? So section 71(5) states that no company shall issue a prospectus or make offer or invitation to the public to its members exceeding 500 members exceeding 500 of the subscription of its debentures, unless the company has before such issue or of appointed one or more debenture trustees, and conditions governing the appointment of such trustee shall be such as may be prescribed. So if you are going for members, or you can say if you are going, because the public limited companies will definitely go for the public for subscription of their shares, debentures, or securities, or whatever. Okay, so if such subscription is exceeding 500, means if you are approaching more than 500 people, then in that case, what is there? Before going for such an issue, they have to appoint debenture trustees for the safeguard of the interest of the debenture holders. So rule 18(2) of the company's share capital and debenture rules prescribes the certain conditions. So what are the conditions? Number one is the name of the debenture trustee shall be stated in the letter of offer inviting the subscription for the debentures, and also in all the subsequent notices or the communications sent to the debenture holders. So the law says that a company cannot deal in the debentures of any company until and unless it has a well appointed debenture trustee, okay, who will take care of all the things. Okay, second is, for appointment of debenture trustees or trustee or trustees, a written consent shall be obtained from debenture trustee proposed to be appointed, and a statement to that effect shall appear in the letter of the offer issued for inviting the subscription of the shares. So what the thing is, just in order to ensure that debenture trustee has been appointed, the written consent has to be a part of the prospectus to be issued. Okay, until unless it is there, you cannot go for the issue of the debentures. Okay, next is, a person shall not be appointed as a debenture trustee if he beneficially holds the shares of in the company, meaning he himself is a shareholder, and beneficially holds means if he is having a less number of shares, which doesn't make sense for his to appoint to vote, then it is okay. Otherwise, beneficially holds means if he one or the other way he is having some substantial voting power in his hands. Okay, because what will happen then in that case, he may infringe with the money of the debenture holders because he himself is the owner of the company. Okay, so इस ये तो वही वाली बात होगी, चोर के हाथ में चाबी देना, right? So it should not be there. So if he must not be a beneficial shareholder of the company. Next is he must not be a promoter, director, or key managerial person, or any other officer or any employee of the company or its holding subsidiary or associate company. So it must not be like, because see, if you will see all this, one or the other way, if you will observe the points, one of the other way, the debenture trustee must be a person who is different from the management and control, or he is a person who can actually see the actual rights of the debenture holders. So he should not be a person who actually can, play with the rights of the debenture holders and make his own money, because he himself is one of the person who he belongs to the company himself. Okay, so it should not be like that. So second, uh, um, he is indebted to the company or subsidiary or his holding or associate company. So he should not be indebted, because the company may tell him to, to just say, okay, we will you be the trustee, and from there you make money, and we will embrace the money, and you will take your share, and your debt, whatever to the company you have given, will be waived off. So he should not be indebted to the company or any of its subsidiaries, holding or associate company. Okay. Next is he has furnished any guarantee in respect of the principal debt secured by the debentures or the interest there. So he should not be a person who has given a guarantee in any way. Otherwise, what will happen? He will execute his guarantee and the things will go for a toss. That should not happen. So, and further, he has an pecuniary relationship with the company amounting to 2% or more of its gross turnover or the total income of 50 lakh rupees or such higher. So he must not be a beneficiary out of the company, or he must not have some pecuniary. Pecuniary relationship means monetary relationship. For example, he cannot be one of the big supplier of the company who is supplying goods to him and goods to the company and is making money out of it. Okay, so in that pressure, he may also, forego his duties as a debenture trustee, or he may be dishonest in his duties because he himself is making money out of the company, and he is also at the remo karam of the directors of the company, and the directors of the company may, tell him to just play around with the debentures money. Next is he must not be, if he is a relative of a promoter or any person who is in the employment of the company as a director or key managerial person, then also he is not allowed to be appointed as a debenture trustee. Okay? Is it okay? So who cannot be a debenture trustee? So one or the other way, debenture trustee must not be getting direct indirect benefits from the company, and because of getting those benefits, he should not come in the in the words of the promoter or the director of the company, and should not play around with the money of the company accordingly. Okay. Next is the board may fill any casual vacancy in the office of the trustee, but while any such vacancy continues, the remaining trustee or the trustees, if any, may act. Right. So there should not be this office. Suppose, for example, a person has been appointed as debenture trustee and he dies. Then what will happen? So until this vacancy is properly fulfilled, there should be some other person who should actually be acting as a trustee. So when such vacancy is caused by resignation of the debenture trustee, the vacancy shall only be filled with the written consent of the majority of the debenture holders. So debenture holders actually should appoint them accordingly. Any debenture trustee may be removed from the office before the expiry of his term only if it is approved by the debenture holders of not less than 3/4 in the value of the debentures outstanding at that meeting. Okay, so he can be removed also, but it can happen only if by a special majority. That is, special majority means 75% or more of the majority. Now, what are the duties of debenture trustee and what duties he should actually perform? So again, section 71(6) actually provides for the duties of the debenture trustee. So what it says, a debenture trustee shall take steps to protect the interest of the debenture holders and redress their grievances in accordance with the such rules as may be prescribed. So if any debenture holder is having any, suppose for example, one debenture holder is not getting interest from the company, so he should actually, he is actually a mediator between the debentures and debenture holders and the company and should act accordingly. Next is rule 18(3) of the companies prescribe certain conditions. Okay, so it shall be the duty of every debenture trustee to satisfy himself that the letter of offer does not contain any matter which is inconsistent with the terms of issue of debentures or the trustee. Now see here. Suppose the company is issuing shares to some other company, or the company has issued some preference shares to other company, and those preference shares or the issue of the shares or any other letter. Suppose, for example, the company is going to issue another type of debentures. So it should be a duty of debenture trustee that he should at least see that the new debentures which are being issued to someone else should not put the existing debentures at a second position from the point of view of redemption. Okay, so the security of debentures, he has to satisfy himself also. He has to satisfy that he has to satisfy himself regarding this, that the any of the rights of the debenture holders should not get infringed. Next is satisfy himself that the covenants of the trust deed are not prejudicial to the interest of the debenture holder. So any provisions of the trust deed should not be against the debenture holders. He should ensure that. Next is he must call for the periodical status or the performance reports from the company so that he can judge, he can see whether the company is performing well or not, or he must see the interest of the shareholders. If the company is not performing well, then he should report it to the debenture holders and would try to take the decision whether the company should go for liquidation or not. Communicate promptly to the debenture holders defaults, if any, with regard to the payment of interest, redemption of debentures, and action taken by the trustee thereof. So he has to actually communicate properly with the debenture holders also and with the company also for any default from the point of view of company, from the point of view of debenture holders, or anything else. Okay, and do such act as necessary in the event when the security becomes enforceable. So he has to actually exercise his powers when the security becomes enforceable. Suppose, for example, the company is not performing well, so he must actually crystallizes, or he can say crystallize the you can say he can actually he can raise the voice for the dissolution of the charge and mortgage of the company in favor of the debenture holders. So, and further, he should call the reports for the utilization of funds raised by the issue of debentures. So, whatever fund has been issued for which debentures have been called upon or debenture holders are called upon to pay, he has to ensure whether the company is utilizing the fund for the purpose for which it has been raised, and then take steps to convene a meeting of the holders of debentures as and when such meeting is necessary or required to be held. So it is his duty to go for the meeting of the debenture holders. Ensure that the debentures have been converted or redeemed in accordance with the terms of the issue of the debenture. So the terms, whatever has been fixed up, it should be properly fulfilled. He has to ensure that and perform such acts as necessary for protection of the interests of the debenture holders and do all other acts as necessary in order to resolve the grievances of the debenture holders with that of the company. Okay, so there are certain exemption clauses in the trust deed. So section 71(7) states that any provision contained in the trust deed for securing the issue of debentures or in any contract with the debenture holder secured by the trust deed shall be void insofar as it would have the effect of exempting a trustee thereof from indemnifying him against any liability for the breach of trust where he fails to show the degree of care and due diligence required of him as a trustee, having regard to the provisions of the trust deed, conferring on him any power or authority or discretion. So any provision which is given in the trust deed, which is actually exempting this trustee. Actually, what the thing is trustee who has been appointed is responsible, is the most responsible person from the point of view of debentures. So in case if there is any clause or any provision in the trust deed which actually releases or relieves this trustee from his any of his duties, then such provision will be void. It will not be applicable. So the liability of the debenture trustee shall be subject to such exemption as may be agreed upon by a majority of shareholders holding not less than 3/4 in the value of the total debentures at the meeting held for the purpose. So there can be exemption, but such exemption may be agreed by the majority of debenture holders, and majority means it has to be a special majority. 51% is not a majority over here. Here the majority will be 75%. Okay, 3/4. So section 71(12) states that the contract with the company to take up and pay for any debentures of the company may be enforced by an order for specific performance. So there was a case, there is a case law also, the note which a company undertook to pay a loan but have given no security. So there was one case law also. You can just go through the facts of the cases. Otherwise, most of the things with examples I have already told you. Okay, so this was all about your debenture trustee, debenture trust deed. So if you have anything to ask, you can ask me. And the rest of the things we can proceed further with tomorrow. So 3 minutes are remaining. So let us discuss. If you have any doubt in this, or you want to ask me anything, you can. Go on. Yes, any one of you, anything you want to. Nothing? Okay, then let me take the attendance. So Astha Khandelwal, Aditya, Ankit, Anshul Goswami, Arpan Mishra, Ashutosh Maharshi, Asmit, आयुष बोथरा, इशप्रीत सिंह वालिया, जानवीर सिंह, जमीमा, करण अग्रवाल, कौशल अग्रवाल, मेघना धुरिया, नमन जैन, नवीन चांदलानी, नव्या सिंह, प्रीतम मिलन, प्रियांशी शर्मा, राघव दुबे, संभव गर्ग, समृद्धि त्रिपाठी, सान्या कंवर, सरवंश सिन्हा, सौरभ यादव, शारा खान, श्रेया धरन, तुषार खंडेलवाल, वंशिका, वत्सल रस्तोगी, and Yashwardhan Tiwari. Fine then. Have a nice day because you don't have classes.
Thank you,
now.
sir.
I hope you have class now or you don't have classes now afterwards.
No classes, sir.
No class.
That's good because our class was just hanging, suspending in at the end of 4:15. So we have pre-scheduled it so that you are free now. You can do your things by your own. Okay, and keep on revising the course, keep on asking, keep on participating in the class as such as you have been doing now too. Okay, thank you so far and all the best and have a nice day. Bye bye. See you tomorrow.
Thank you,
Bye,
sir.
sir.
Have a nice day, sir. Bye, sir.
Bye bye bye.
Bye.